All right, an owner hires an architect to design a residence using the standard AIA set of contracts, but the owner fails to pay the architect at any of the agreed upon milestones. Through 90% construction documents phase, the architect terminates the contract for owner non-payment. The architect offers the owner 7 days written notice that she's terminating the contract for cause. Which scenario best describes the state of the project? Most of you guys got this right. The owner loses his non-exclusive right to use the drawings that the architect had created. So the architect creates the drawings, the architect owns the drawings, the architect grants a right to the people who need to know. Those people are allowed to use the drawings, like the owner and the contractor. And we have with us our special guest today, Michael Hanahan. You guys know him of the Perkins Coie lectures, used to be called the Schiff Hardin lectures. It's called the Michael Hanahan lectures. He suffers from three names, and so it's like the worst marketing situation ever. Yeah. But he's our guest today, and he's going to now share his screen.
So one thing I just want to say on the question, and what I thought, I was glad that people all kind of gravitated to the first answer. A lot of people will read into that question. It says that they failed to pay at the milestones, and some people will read in, well, they may have paid later. There may have been some payment. And so, like when I give my exams, I tell my students to read the question very carefully, because you don't want to read, and I say this because as a lawyer, and when you read contracts and everything else, you don't want to read into something that you may think. You just got to go with what's the language in the question, or in the language in the provision of the agreement. And in there, that question had nothing to do, there was nowhere in that it said any payment was made. And that's why it was a difference between answer 1 and answer 3. Had there been some payment made, the owner could have made the argument, I get to retain the rights for certain portions that I have paid for. It probably wouldn't be sufficient to build the house, but that could have been an argument. But there was nothing in that question, so that's why the answer was number 1. So, okay, with that in mind, I'm going to flip over, and hopefully, when I share this, things will work properly. Okay, so what I'm going to do today is I sometimes call this my scared straight speech. I'm going to go through some of the some key provisions and some key elements of the B101, which is the agreement that we were just talking about in that question, and just kind of go over the overview of the things that you guys need to pay attention to when you're out there practicing. We're not going to go through every single provision, and if you've listened to my lectures, or if in the future do listen to my lecture, I do spend about 5.5 hours on this document alone, where I go through every single provision and I explain, hopefully my goal is to explain it in layman's speak and just common language as to what the provisions mean. But for this one, I'm going to go and just kind of the ones that are elements of the agreement, and how the structure works, for you guys to kind of understand the role of the AIA and how it applies to you. So the first thing I'm going to put up, the first thing I have up here is the structure of the agreements themselves. So on the AIA contracts, you may or may not know that the A series deals with the construction side of it, and the B series deals with the design side. And then in each series, there's a breakdown of the different sizes of or types of agreements. And so we have the most common is the B101. There's the 103, 104, 105. I don't know whatever happened to the 102. I don't think it ever existed. They used to be 141 and 151, different numbers, but they changed it to this sequencing of numbers. But this chart just kind of shows you where you use these agreements. And the B101, as you can see, covers about 70% of the types of agreements, of the types of projects you're going to be using. And so if you, on any project that you find yourself, if you're not sure which agreement to pull and you use the B101, you're always going to be safe. Even if it's a very large project or a very small project, you can use the B101. The 103 it just takes it's for more complex projects. I would say I use it, this says 15% of projects. I may use it more like 5% of the time. And it's just kind of the 101 on steroids. The 104 is going to be on smaller or more medium-sized projects, and it works in conjunction with the A104, which is a single document that's on the construction side. And so a lot of times you'll find a project where you use the A104 with the owner contractor and not with the A201, but just the A104 is a single document, and the B104 for the architect. And it's smaller projects, sometimes maybe interior work, something that's lower dollar value. And then for your B105, which again, it says about 15%, I think I use that maybe 2 or 3% of the time, because if you're going to use the 105, you probably don't want to pay a lawyer because the project is too small. But you guys, as the architect, can pull that off the shelf and use it for your projects. Now, with all of these agreements, there's going to talk about 5 basic services that you're going to use. And not all phases will be part of your services. Sometimes when you're negotiating with the owner, you're going to say, well, I don't want to do all of these, but the traditional is broken down as to your schematic design phase, design development, construction document phase, bidding and negotiation, and construction phase, or sometimes they call this construction administration. What often happens with an architect or how the owner looks at it is your schematic design, design development, construction document phase are almost always what you're going to do. Sometimes the owner will have someone to handle procurement, maybe a lawyer, maybe they're going to have an owner's rep, and somebody else will be handling the bidding and negotiation. And so the architect would not necessarily be brought in to help prepare the construction contract. As a general matter, I recommend to my owner clients not to have the architect prepare the owner contractor agreement, because I think that they can get into trouble. They may not understand all the ins and outs of the owner contractor relationship from the owner's side. And so what happens is in this bidding and negotiation phase, the architect may prepare the owner contractor agreement, and then it's not sufficient, something goes wrong, and then the owner's looking back at the architect and saying, you prepared this contract and things are going south to the contractor, and now you have an owner mad at you, even though it's probably just the contractor's fault. And this last phase is construction administration phase. That's when the actual construction work's going on. Sometimes an owner doesn't want to pay the architect to walk the site. They'll have an owner's rep do that. Sometimes there's limitations as to what you do. Maybe you only walk the site once every 3 months or something to that effect. Maybe you have a sophisticated builder who handles all this himself. But most of the time, an architect is going to do the construction phase, construction administration, review the work as it's being performed, make comments and what's necessary to make sure the work is being performed in accordance with the contract documents. And we'll get into that a little later as to how that will affect what you guys do on the construction phase. So the next part that I think everybody needs to know when you think about the agreement is it talks about the services you're going to provide. So the AIA contract is very clear that it has the description of what your basic services that are being provided under the agreement. And then later in Article 4, there are what's called additional and supplemental services, and they both are extras that you're going to be providing, but they carry a little bit of a different definition. But the point being here is that under the basic services, it's a set description. You're going to provide structural, mechanical, electrical, and then, of course, architectural to design. Those are your basic traditional services. The additional services and the supplemental services, additional services are if I'm already providing structural services, but I need to do specialty structural services, it's the basic plus, so it's in addition to my basic services. Supplemental services, under a different defined capital S for supplemental services. Those are like a list of things that are not considered your traditional structural, mechanical, or electrical. So if you're going to be doing lead, or if you're going to be doing landscape, or if you're doing civil, those are supplemental services. And that is structured like a menu. But the point of why I have the slide up and the point of the way the documents are drafted, it's very clear as to what the owner is going to be getting. And it's helpful for you to understand. So when you're explaining to the owner, and a lot of owners won't really know, they just know I need an architect, you can explain to that owner, here's what you get for me for my price for the basic services. If you want me to do more, here's where I'm going to ask you to pay me for more. And you can make it very clear and walk them through. So the usual and customary is something that we're going to talk about a little bit and where that all fits in. And that gets into some questions of what the standard of care. So with that, I'm going to go now to the exact language in the agreement from these more important provisions. So the first one here is your contractual standard of care under Article 2. So 2.1 says, and by the way, the way the AAA document's put together is Article 2 describes the services you are providing on a kind of overall, and then Article 3 gets into the breakdown of those phases of services. 4 is the additional supplement, 5 gets into the owner stuff, and so we get through the different structure of how the agreement's put together. But under Article 2 of what the architect's services are, says they shall provide professional services as set forth in the agreement. Professional services here is important because you are looked at differently than the average person. You are a professional providing services. That's why ultimately you get professional liability insurance. And so you're looked at by society, the public, as somebody different than the average Joe or Jane. So that's why you're a professional. So you need to provide professional services. That's number one. And then under 2.2, this is the true standard of care of what you will be required to perform. It says you will provide your services, which are of course professional services, consistent with professional skill and care ordinarily provided by architects practicing in the same or similar locality and under the same or similar circumstances. So while you are a professional, you're just an ordinary professional. You're not the super architect. You're not the highest architect. You are just doing what the average ordinary architect provides in the same area. So if you're working in California and there's earthquake codes, you have to know those because that's what the ordinary architect in California does. But if you're in Illinois, you don't have to know those because it's not ordinary for an architect to be designing to earthquake codes in Illinois. Or under the same or similar circumstances. This talks about what's the project. If I'm going to be designing a hospital, I'm going to need to know what the professional ordinary architect does in designing a hospital in that location. And it's not what was going to be going into a house or what's going into an industrial building. And the same is true on the other side. If I'm going to be putting in a strip mall, I don't have to design it with the standards that would be in a hospital. So it's the location and the type of project. And then as you continue on, say the architectural performance services as expeditiously as in consistent with such professional skill and care in the ordinary progress of the project. This is making sure that you are acting in a timely fashion. So we have the requirement to be the ordinary professional, but it's tied to location and type of project. And then you have the requirement of making sure you're performing expediently in what you're turning around. Because as we all know, in construction projects, one of the biggest problems is delay in schedule and time. And that's where the costs and losses can be the most significant. And so in that standard of care, you are also obligated to keep up with schedules and what's normal. Sometimes what's going to happen when you enter into that contract, you may not have a design schedule. And the owner still may be looking for you to meet deadlines. And if you don't have a project schedule that's been created, you still have to turn things around, which is typical for professional skill and care in the ordinary progress of the project. Likewise, once the project has started and the construction is ongoing, you also have to keep things moving on a normal basis. So for example, if the owner gives a submittal and says, here are 3 different types of brick I want to use, please tell me which one is the one that fits with your design intent, you have an obligation to turn that request around and show which one of those 3 bricks you want to use in a timely fashion. And that's tied again to the standard of care here. So now there's sometimes when you're going to find where the design and what you're designing, you may not have actually hit the standard of care. You may have designed something that isn't what's ordinarily and normal, something like this, where we have a stairway that goes into a stairway and it doesn't quite work. So those are the things you want to kind of look. Did you meet the standard of care? Clearly here you did not. Now, as I said, when we talked about Article 2, it talks about that you're going to be providing the basic services. And so in Article 3, we now start to more define clearly what the definition of your work or your services are going to be. So 3.1 says, again, your basic services are usual and customary, structural, mechanical, and electrical engineering services. Services not set forth in this Article 3 are additional services. Now, sometimes when you get into negotiations with the owner, They may ask you right out of the box to do civil services, and your bid may include that. Then this provision may be modified, say structural, mechanical, electrical, and civil engineering services. Or it would be in additional services that we mark up later on in Article 4. There's different ways to do that. But normally, every architect's going to provide your architectural designs, the creativity, and these usual and customary services. Then 3.1.2 talks about the architect shall coordinated services with those services provided by the owner and the owner's consultants. And this is really important because now we have our usual and customary services. I'm working on structural, mechanical, and electrical, but maybe the owner hires a specialty designer for the audio visual of their project, or whether it's a residence, whether maybe it's a sports stadium or whatever. So they bring in a specialty consultant to do all of the AV and the low voltage. Now, you're doing electrical designs, you're doing structural designs, you're doing mechanical designs, and those all may be impacted by where the AV system's going in and how the home runs are going to be and how where the ductwork is going to fall. And so you need to coordinate under 3.1.2 shall coordinate your services with those that the owner brings in. And that's a combination of assembling bringing in their drawings and specifications, making sure that yours don't conflict with theirs. And traditionally what will happen is the architect, you are kind of the leader of the situation. So you have designed your space and where your structural, mechanical, electrical engineering work is going to go. The consultant comes in and brings their designs for their low voltage and their audio visual and stuff. And if it doesn't fit in with where you have your spaces, you need to go back and tell them they have to modify. And then it becomes a back and forth communication between architect and the owner's consultants. The next part of this, though, is so that's kind of an obligation on you because you're coordinating your services. The next part, though, is you need to have some protection. Well, what happens if the consultant gives you something that's not accurate, and when it's being constructed, they don't all fit into the area where you thought you were going to run your wires or your electric or your plumbing or what have you? So this provision protects the architect. It says shall be entitled to rely on the accuracy and completeness of the services and information furnished by the owner and the owner's consultants. So when those consultants provide you with their drawings and diagrams for their HVA, or their audio visual and their low voltage, you have to be able to say to the owner, I'm not going to check their math. I'm not going to make sure they did this correctly. I'm going to take this and I'm going to coordinate it into my drawings. And if it turns out they gave me something in error later on, I'm protected by this language here. I don't have to pay for the fix, they do. And then the last provision here that I think is relevant is while you don't have to coordinate their work, or you don't have to check their math and look to make sure that their work was proper, you can rely on it. If you become aware of an error or omission or inconsistency in something that comes from the owner, you need to let them know. So this is the more of if you see something, say something. It's not like I have to go to the next level to check to make sure they did it correctly. But if I'm looking at it and I, with professional knowledge, can see something's wrong, can see there's an inconsistency, you do have an obligation to raise your hand. And what I want to talk about, a completely different element of this paragraph, but I use as an example so you understand how contracts work and how they put this document together. So the AIA contracts have been around for 120 some years. And they are used, obviously the AA started, the architect started, so they are architecturally favored. They help protect you as the architect. Every 10 years, they update these documents, and there's committees that sit down. I have a couple of friends of mine that are on the committee, and some people on the committee represent owners. Some people on the committee represent contractors or subcontractors or other people that have a vested interest in this document. And so if you look at this agreement, what happens here is you're going to see the language in this first section that's requiring the architect to do something. And even though it's the owner's consultants, this type of provision was brought in probably when over the years and years and years they've modified and updated this agreement, was probably put in by somebody, either an owner or a subconsultant, that says, hey, the architect has to kind of take lead in this area. So this is language placing an obligation on the architect that the architect, if they had their druthers, it would be silent. The next provision is something clearly put in by the architect to protect themselves. And then the last provision says, okay, you can protect yourself here, but the owner clearly puts this last provision in that says, if you see something, architect, say something. So this paragraph on its own has a give and take back and forth to balance the interests of everyone that's going to be doing work on the project. And that's one of the reasons why the AAA contracts are so successful, is because it's fair and everybody has a voice. And as you read through this, there are other provisions where you can see two or three very distinct voices, owner, contractor, and architect, as the provisions. You get protection here, I get a little back here. So there's a give and take in these provisions. So I point that out. That's more about the structure of the contract as opposed to the content of what they say in these provisions. Now, it just is another thing for the entertainment value. Here we have the architect doing your usual and customary. We have your mechanical, which is your plumbing. We have your electrical in the shower, and there's probably some structural holding this wall up. So this one picture, not that you would ever want to have a circuit board or your fuse box here in the shower, but this is something where obviously somebody trying to figure out how to design didn't do very good coordination, but it's all covered right here, both your structural, mechanical, electrical. So now, as I was talking about your basic services for the work that the architect normally does, Article 3.2 covers your schematic design phase, and that's going to be anywhere between 10 and 20% of the overall work that you're going to do on the project. And in that, you're going to be doing drawings, you're going to be doing volumetrics, you're going to start fleshing out what the building looks like, you're going to be working back and forth, and you're starting to create some of the buildings. There may be some limited renderings and some other stuff, but it's still in its infancy of what your project is going to be. 3.3 covers your design development. Now we're really starting to flesh things out. Walls become having thickness. Corridors are put in instead of just room spaces. You start to draw some elevations. You get some axonometrics. You get as you put together the volume of the space. And this is going to be more refinement that you're working with between you and the owner. And what you want to make sure when you're talking to the owners, you're providing these services, is that they understand, going back to the question that we started with the session today, at the end of each phase, you want to make sure that the owner signs off and blesses what you've done to date, and you've been paid through the end of that phase. What you don't want to find yourself, which that architect obviously did, is they did schematic work, didn't get paid. They started doing design development, didn't get paid, and they got themselves all the way in through 90% of CD phase, construction document phase, and they still weren't paid. And what they should have done is at the end of each phase, they should have said, I'm going to stop until you pay me. And again, that's fair by the architect, and it's something that the owner should understand. So as you work through your phases, you want to make sure you're getting paid. So 3.4 covers your construction document phase. So our design developments could be another like 15%. 3.4 covers your construction document phase. That's going to be roughly 40 to 45% of your work. This is the bulk of the services that you're going to be providing, the largest chunk of the project. And that's where you're going to have the most hours. So if you listen to some of my lectures, I have the economics of construction, and I have running your own office, and I talk about how you need to build your budgets and your estimates based on a number of hours that are going to be necessary to perform the work in these various phases, the biggest one being the construction document phase. 3.5 covers bidding and negotiation. That's if you want to put together the contracts and help them bid out the project. And then 3.6 is the construction phase. So while the contractor now finally comes on board, so we've got 4 of the 5 phases do not involve the contractor in your traditional project of your design, bid, build. The contractor hasn't started doing work. Once we get to the contractor going on site and mobilizing, starting construction, that's when the architect's construction phase services begins. Okay? Moving forward, when you look at the 3 phases, sometimes what they talk about, and this is something I just wanted to throw in, that's newer in some of the newer documents, the AIA. The AIA has tried to understand and respect the concept of sustainability and other things. So in this version, and I know we're on the 2017s, the next one that'll come out will be the 2027. So we're about halfway through the cycle of this document. They added this provision that the architect shall consider environmentally responsible design alternatives. So what's interesting about this is a shall. You, as the architect, are required to consider the environment and how you design. Now, that doesn't mean you have to design a building for the owner to a silver or gold LEED standard. What it means is while you're designing, you need to think about it being environmentally responsible. And I think that's good. What'll end up happening often, though, is the owner, when you come to them and say, let's use this type of brick or this type of material or this type of extra glazing so we get more sunlight or whatever, owners may or may not want to pay for that. But you still have an obligation under the contract to shall consider these in your design. And then later it says the owner maintain other environmentally responsible design services under Article 4. So your basic services says you need to think about it. But Article 4, as we talked about, has the additional and supplemental services. That's if they want a LEED certification, or if they wanted to go further than just considering what's environmentally responsible to your design being much more intent. So continuing on in we're going to jump forward. That last one, by the way, was under Article 3.2, which, as I said, was your schematic design phase. This language continues on in 3.3 as well, because you're in your design development. So schematic and design development is when you're thinking about this. When you get to the construction document phase, an article, which would be 3.4, the sections under 3.4, those you will have already made your decisions on the environmentally responsible. So what we're going to do here, just because I want to talk about, again, the more important provisions, is we're jumping ahead to the construction phase. So now you've gone through, you've finished your construction documents, you've issued them for bid, the owner selected a contractor, and now we're out there building the project. So under 3611, it says the architect shall provide administration of the contract between the owner and the contractor as set forth in the AIA A201. So the contract is the A201 and you're administering it. Now that doesn't mean you are telling the contractor how to do the work, but you have a responsibility and obligation to understand what is in the A201 and how it's being administered to make sure that the project, when it's complete, will conform in accordance with the contract documents. So that's an obligation. You shall provide administration of the contract. That's, again, a basic service. And then we get into what that means, what portions and what obligations you have. And again, you'll probably see this or hear this in my lectures or see this when you're looking at the documents. The language that's in this section 3612 is almost word for word mirrored in the AIA A201, the language for the owner contractor. So it's consistent between those. And so what it has here is it says the architect shall have the authority to act on behalf of the architect only to the extent provided in the agreement. So they can't go further. They don't have the obligation, or they're not going to be the owner's agent unless it specifically says they have the authority to speak or act on behalf of the owner. So throughout the agreement, there are various sections where it says the architect on behalf of the owner shall be doing this. A lot of times what will happen is the contractor will assume that the words by the architect or the actions by the architect are the same as the owner, and they are not. It's because it's only where it's limited and provided in the agreement, and this language is also mirrored in the A201. So what you want to make sure is that the contractor doesn't think you are the owner's agent when in fact you are not. The next part that's important under this section is the architect shall not have control over, charge, or responsibility for means, methods, techniques, sequences, or procedures. So this means basically you are not going to tell them how to swing a hammer, how to crank a torque wrench, how to do the work. What you're going to do is you're going to look and say, was the wall supposed to be in this spot or is it in the wrong spot? You can tell them that they did something in the wrong location. You can tell them that they built it. It doesn't look like the drawings, but you're not going to tell them how to build it. You're not going to tell them how to construct a brick wall, how to put up steel, how to install a window. Those are what's called means, methods, technique, sequence. And if you ever, and this is part of my scared straight part, if you start directing traffic and telling the contractor how to perform their work, how to swing that hammer, how to turn that torque wrench, you have now stepped outside of your protection of this provision, because this protects you. and you put you and your company at risk for liability. So you want to stay away from telling them about any of this stuff, even if you may know better. The next part of this is it talks about safety precautions and programs. Again, you don't want to be talking about if you walk around the project site and you see something that's unsafe. If there's a hole and there's not barricades or some type of tape around it, and you see the hole, and this is a problem because we're all human beings, you see an unsafe condition, you don't want to raise your hand and start talking about it because, again, you have the protections from this contract that says you do not have control nor you were in charge of this. And so if there's a hole, and I had a case of this early on in my career, where they were renovating the Rookery building here in Chicago, and they were doing some work on the elevators, and they didn't have a barricade in front of the elevator shaft, and a drywaller fell down and broke his leg. So there was a lawsuit about that. And I represented the architect. And the architect was, of course, safe because they had the get out of jail free language that's here on the screen. We're not responsible for safety. And so we thought we were going to get out of the case because we had this protection. And what ended up happening was through the course of discovery and the thousands of documents that are exchanged, at one point, one of the architects on site wrote down in meeting minutes and said, elevator door is not protected by barricades or other fall protection. They didn't tell anybody about it. They just wrote it in their notes. But as soon as they did that, we were stuck in the case because we had assumed making an observation about a safety issue and didn't do anything. We had taken control over it, even though we should have done, we could have raised our hand or nothing. And so we had to stick in the case. Our liability was significantly less than the contractor, but we were stuck when we had this protection. So that's a thing to think about is, well, how do I handle that? When I do see this unsafe condition, and the answer is what I tell all of my people, and I say this, and I've gone out on record this many times. You don't ever want to write it down, but you do go up and you walk to the project manager and you pull him or her aside and you say, hey, there's no barricades in front of that hole. You need to fix it. You are now being a human being, making sure there's this unsafe condition that's being hopefully rectified. Because you've only said it to the contractor in their ear away from everybody else, you have not put documentation out there. So you're, in my opinion, you're appeasing your moral being by saying, I saw something unsafe and I did something about it. But you're not exposing yourself or your company. Now, technically, people are like, well, why wouldn't the contractor say, hey, you told me about it, so to keep you in the case. The contractor, you're like, why wouldn't they call the bluff or say he told me about it? Well, the reason why is the contractor's not going to admit if they never put a barricade in front of that and the person fell in it, they're not going to admit that somebody pointed out to them. The worst thing the contractor can say was somebody told me about it to try to keep the architect in, and then realize he never did anything about it. So that's why I say to protect yourself, you can raise safety issues. I wouldn't do it on a regular basis, but you can pull the project manager aside and say something, but don't write it down and don't take responsibility over these means and methods or the safety precautions. And then the last thing here, which is very important, is the architect shall not have control over, charge of, and should not be responsible for acts or omissions of the contractor. So even if you saw something and you didn't see something, you're like, I have a project right now where the architect didn't see a lot of mistakes. They should have put it down on a punch list, but they failed to do so. So the architect failed in their construction administration work to properly punch out the project and keep track of what was going on. And so the architect does have some exposure because the work wasn't being performed in accordance with the contract documents, which is different than means and methods. But it doesn't mean that just because I, as the architect, failed to do my job, doesn't give the contractor any freedom or relief because of the fact that they had errors or acts or omissions. So this language here that's in this last paragraph still says, regardless of what the architect does, contractor's always going to be responsible for the work that it did poorly or not. So a couple more kind of interesting photos for your means and methods. Here we have some guys using a Sawzall and a power line. So they're going to cut through this piece of metal and hit a power line. That's something you might see as an architect. You don't point it out. But obviously, clearly, these people are not working with safety issues. This one's a little bit more probably staged, but he didn't have the right thing, so he starts to cut, and obviously this guy's going to potentially be injured. So just a couple more examples of where you don't want to say something, or certainly don't want to make a record of it for the means and methods or safety precautions. Okay, continuing on for your work under the construction administration, site visits. So under the AAA contracts, you only have to become generally familiar with the progress and quality of the work and to determine in general that the work observed is being performed in a manner indicating that work, when fully completed, will be in accordance with the contract documents. That means you don't have to be the minutia. You don't have to see every single thing. The contractor is going to provide a warranty for its work covering everything. That's their responsibility. The architect, sure, was going to walk the project site, but if they don't see everything, that doesn't mean they violated the standard of care, because it's generally familiar, and the work, the completed in general, will be completed when fully completed, will be in accordance with the contract document. So you have this kind of much more wiggle room as the architect in performing your observations on the site. It also talks about they shall not be required to make exhaustive or continuous on-site inspections to check the quality or quantity of the work. Some projects you're going to be there once a week. Some projects you're going to be there once a month. Other projects you may be an on-site architect there every day. It's going to depend on the budget, the sophistication of the owner, the complexity of the project. And so as a general matter for your basic services, you don't have to make exhaustive or continuous on-site inspections. I had a case years and years ago where the architect was the owner that hired the architect was actually a builder. And so they said, you need to design, it was a series of townhomes. You need to design these townhomes for us, but we'll take it from there. We know how to construct this thing. The architect's like, well, I still want to do some CA. And they said, okay, what we're going to do is we're going to set aside a bucket of money. So there was a pool of money, and we'll have you come out when we want you to come out. So every 3 months, they decided, you come out and walk the project site for a day, and we'll pay you for your hourly time, and we'll take that out of the bucket of money, because they were like, of course we can do everything. We've built things for years. And what ended up happening was, between one of the visits and another visit 3 months later, the townhomes were being framed. By the time the architect came back, they were all buttoned up. And so the architect couldn't see what had happened with the HVAC systems and the ductwork and how some of the other elements of the house or the townhomes were being constructed. So it ended up that the airflow and the way the air circulated in the attic space of this townhome, the air wouldn't move because of the way the contractor constructed it. And it was not consistent with the architect's drawings. And so in the summertime, because of the heat and the air conditioning system, mold developed in there because of the moisture in the air. And then the mold went down into the walls and it went into the residences. It was a really, really bad case. So we had to rip open all the ceilings and roofs of these places and decontaminated them all. And the owner, which was a builder, sued the architect and saying it was their design. And we said, no, it wasn't our design. A, B, you didn't build it in accordance with our drawings. They said, well, you should have caught that. And we went back and pointed to this continuous and exhaustive plus our schedule to say, no, we didn't have an obligation to have X-ray vision and see through walls. So you can use the contract to protect yourself. And then the last one, the architect has an obligation to the owner to keep them previously informed. And you need to report to the owner known deviations from the contract documents related to the construction schedule, and then defects and deficiencies observed in the work. So while you're not going to tell the contractor how to do the work, the means and methods, if you see something that you think is a problem, even if it is how they're doing the means and methods, you need to keep the owner informed of that. Say, this is what I'm observing. I saw this on the project site. And again, this is where the big case that I'm working on right now, there were many, many defects that were just completely missed by the architect. They failed to identify known deviations and deficiencies in the work. In other instances, we have one of the conditions that exists in this project was the architect properly designed how the ice and water shield system worked on the roof. The contractor deviated from how the ice and water shield system was designed. So the contractor did not follow the construction documents. The architect didn't notice it during construction, but as the house got closer to completion, there was leaks that were occurring. So the architect investigated and stated and sent out a notice to the contractor that said, we saw this defect and deficiency. You did not build it in accordance with the contract documents. The contractor saw that, realized that there was a problem, and went back to the roofer and said, you didn't do this properly. And by that time, the argument is the architect has done its job. They designed it properly. They raised their hand at a time when it was necessary to raise their hand. And now you would think it was up to the contractor to go and fix it. The problem that happened here was the architect, after sending its first notice, never followed up to say, hey, contractor, remember that thing I told you about the ice and water shield? Did you fix it? Never followed up with that last phone call or that last email that says you have or haven't fixed it. The replacement of this roof is going to be in excess of $1 million. And the architect's going to have some liability, not nearly as much as the contractor, because of the language that says, regardless of what the architect does, the contractor is still going to be responsible for its work. But the architect didn't complete their work after they had identified the known deviations. So that's just as an example. So what are some of the things you may see on a site visit? Well, this may be an issue. You have an obstructed view pole here. Maybe we don't need the seat here. Maybe you need to point out to the contractor that this is something you don't want to have. So just as an example of what you're going to see from a site inspection. The other thing that's in this section under 362 talks about the architect has the authority to reject work that does not conform with the contract documents. This is one of the few times where the agreement specifically says the architect has authority. They are, in this case, acting on behalf of the owner and saying, I'm rejecting work because it's not in conformance with the contract documents. So could they have rejected the work that's on this page here? If the contract documents don't have a chair here, yes, they could have rejected that work. Or if the pole was placed in the wrong spot, they could have rejected this work. And that's based on the authority under 3622. You can also have the authority to require inspection and testing of the work. So sometimes maybe my architect in that case where the mold was, when they went to the project site, they could have said to the contractor, hey, I need you to open a couple of these roofs so I can inspect it to make sure you did it properly. It's not an obligation, but the architect has the authority to do that. I need you to remove that drywall to make sure that the plumbing behind the drywall in the bathroom has been properly installed. Now, when it goes, so this is giving protection to the architect and giving them some rights. It's protecting the owner. And then we have this latter part of the provision that kind of goes and, give a little bit, take a little in the agreement. It says, neither this the authority of the architect nor a decision made in good faith to exercise or not exercise such authority shall give rise to a duty of the architect or the contractor, subcontractors, or otherwise. So if I tell the contractor to take something down and disassemble it, I don't owe a duty to the contractor for that. I'm just doing my job to inspect. And so this, again, you're looking at protections to make sure of where your authority is and who your relationships are. And you do not have any agreement, architect and contractor. Your relationship all goes back to the owner. Here's something that you would want to reject. Now, it's not rejection of taking out the whole plumbing fixture, but the contractor has to bring their plumber back in to adjust the numbers. So this is just a simple thing you're going to be doing as you're walking a project site, something on a site visit and inspection. You would have the authority to reject that this work has not been properly completed. Here, maybe something different. We have another set of stairs that kind of goes up and ends in a window, or I have no idea in this lower picture why they poured this additional pad and then made room for a swing of a door. This would be something that, unless there's some explanation or there's a design of why we have this, that this would give you the authority to reject the work. In both instances, the stairwell wasn't properly built, and this doorway pad wasn't properly constructed. And you can reject that work if it's not in conformance with the contract document. Another thing you're going to do under Article 3.6, and this is very important for an architect, is certifying payment. And so what happens is the application for payment comes in from a contractor. They say, this is how much it's going to cost. And you walk around the project site and you need to make sure that you certify payment and tell the owner you should pay. To protect yourself, it says, to the best of the architect's knowledge, information, and belief. So you don't have to know everything. It's just to the best of your knowledge, information, and belief. Again, if you can't see behind the walls and you're certifying payment, you don't have to be responsible for everything. It's the architect, the contractor that has the warranty, not the architect. We're quickly moving to Article 4. These are the additional services. And so we have the kind of list of additional services here that you could be providing. And this is kind of a laundry list. I'd only put in a few of them, but there's a long list in the AA documents. And for each one of these additional services, you can get money and additional money from the owner. Say, hey, we can provide this. We can do lead. We can do fast track. We can do civil. That's in addition to the basic services of the electrical, mechanical, and structural. Another element that you want to identify in your additional services is how often you're going to review shop drawings. These are blanks and you fill these in. How often are you going to visit the site? How many times are there going to be inspections to make sure that they're substantially complete? And then how often you're going to do inspections for final completion. You want to put these numbers in because once they exceed these numbers, if you're supposed to visit the site once a week or once a month and they ask you to come back once a week, you've identified here what you're being paid for under your basic services, and anything in excess of that would be additional services. I don't know if we're running out of time here because I talked a little bit at the beginning. So where we are on time, Michael, should we keep going? I got a few more slides.
Sure, let's keep going.
Okay. So for under Article 5 here, these are the owner's responsibilities. So we looked at 2 and 3 and were the architect's responsibilities. 4 was some more architects, additional services. 5 talk about what the owner should do. The owner needs to provide information in a timely manner. So just like the architect in the beginning, you had your standard of care, which you have to be timely, so does the owner. The owner needs to provide surveys to describe the physical characteristics. And so that's important to see where the project site is, what the sight lines are, what utilities are. The architect doesn't have to do that. That's up to the owner to provide that. And then the owner kind of in conjunction with the previous language earlier where the architect needs to coordinate its services with the owner's consultants, it says here the owner should coordinate the services of its own consultants with those provided by the architect. So it's put some obligation back on. The owner has the obligation to say to that low voltage contractor or the AV consultant, hey, you must follow what the architect says. You need to do this. So it places obligations back on the owner for that. Article 7, also very important in the agreement. This is your instruments of services. This talks about your copyright. And so the architects shall not be, they're deemed as the authors and owners of the respective instruments of service, which we talked about in the very beginning. They own all of it. They retain all common law, statutory, and other rights. The licenses for you can grant the license to an owner that allows for expansion or alteration of the project. You can do that. The license granted continues after a proper termination for cause. Again, if there's been payment made that's why I kind of made that comment in the beginning. As long as payment's been made, the license can continue. But if no payment's been made, you can't get the benefit of that. And then finally, if the architect properly that's with the owner's termination, I'm sorry. And then if the architect properly terminates the agreement, which is what we did in the earlier provision, the license does terminate. In this case, it was the architect because he wasn't getting paid. And then this section here talks about compensation. So we get to jump to Article 11. This talks about if the owner terminates the architect for convenience, meaning, hey, I just don't like you anymore. You didn't do anything wrong, but I just don't like you. Or the architect terminates under 9.3, the owner shall pay a licensing fee as compensation for the continued use of the architect's instruments of service. So what can happen in a project is we get to the end or we get somewhere along the lines and the owner and the architect are not seeing eye to eye. But the owner likes some of the stuff the architect does. Maybe not all of it, but only some of it. So there's a termination. There's a separation between the parties. This provision allows the owner to use the architect's instruments of service, but they have to pay a licensing fee. And that's something that you can either negotiate in the beginning, or it can be something as the termination occurs, that you can make sure that it's paid. And then the last 2 slides I'm going to put up here talks about your role dealing with the A201. The architect's what's called the initial decision maker. The initial decision maker is kind of like the neutral. It's before you get a mediator. So contractor comes to owner and says, hey, I need to be paid more for this, or I need a schedule change. The owner says, no, you shouldn't. It's in the drawings. Well, they go back to the architect and kind of be the intermediary between them. And it's the initial decision maker to say who was right, who was wrong, should the contractor be paid, should the owner not pay? And before that, if it doesn't, then it goes to claims resolution. After the architect makes this initial decision, if you can't resolve it, you go to claims resolution. First is mediation, which is a non-binding business resolution. And then second is arbitration. And in the current version of the BO1, you can opt out of arbitration. You can just do litigation. So this is how you solve and resolve claims between the parties. And then finally, under the initial decision, under the A201, this again is the owner contractor side. It's trying to recognize what's in the owner architect agreement. By default, the architect is the initial decision maker. The IDM is the initial decision maker, should treat the process more seriously than just normal. It can help settle claims prior to mediation or arbitration. These are the benefits for it. It's a continuous condition of mediation, so you have to have the IDM come in, but only before final payment is due. So if final payment's been made, the initial decision maker doesn't have to come in and do its work. The decision is final and binding, but it can be overturned. So whatever the architect decides, it can be as binding on the parties, but it can be overturned if the contractor still disagrees and they want to take it to litigation. And then either party, after 30 days of the decision, can demand the other party file for mediation. So maybe we have a binding decision by the architect. People don't like it, so then they can demand mediation. And then if it's only aesthetic, so it's not about cost or schedule or those types of things, it is no longer considered a final decision. So the decision of the aesthetic sometimes gets pulled out of what the architect will have on a normal project, the architect always has 100% overriding on aesthetic. But if we get this decision later on, it can pull it out of being the architect has all authority on the aesthetic.
Mike, one of the questions that came up a few times is plumbing just under mechanical? So when you say mechanical, I know you did clarify it later, but I wanted to bring it up there for those who might have missed it.
Yes, plumbing is considered. So you would have plumbing, HVAC, those are what would fall under your mechanical systems.
Okay. Any questions? Go ahead and raise your hand, or you can put it in the Q&A. Preferably raise your hand.
So here's a question that says, what kind of protections are provided to the architect by the AA contracts, if any, in the event that the architect prepares existing condition drawings that contain some type of error or omission? So that's something that, when we talk about existing conditions, it could be one of two things. It could be that it's in the beginning. So the existing conditions may be, what was the site like, and did they have a responsibility to make sure that they properly map the site, even taking information from the owner of the surveys and where the utilities are and everything else. Another something where maybe existing conditions are what you would call an as-built condition. So after the project is built, they prepare as-built drawings. And so there is not a specific language that talks about either or, but where you would look to is the standard of care. So if you're hired by the owner to come out and do a survey of what the conditions are that exist, you need to be able to perform in accordance with what the standard of care of performing those services. Years ago, I represented, well, for many years, for probably a decade and a half, I represented Navy Pier here in Chicago. And when we renovated Navy Pier, the owner didn't, because the pier had so many things that had happened over its long history and everything else, it did not want to be responsible for figuring out what was underneath the surface. And so when we retained the architect was specifically required to do all of those surveys, and they hired a special consultant for that, and we held them to the standard of care. And many months later, when the contractor was doing some work, there was issues with the way some of the drainage document or the drainage piping worked, because of whether they're going to offshoot into the lake, which it had done years and years ago, but now it's illegal, the EPA issues and everything else. And so we had to work that out between the contractor, the plumber, and the architect as to whether their survey drawings were proper. So that's something that not specifically covered by exact language, but you have the standard of care.
Mike, there's one question. I love your idea of being a human by just kind of whispering it to the whoever's in charge on the site. Is the official kind of stance for the AIA documents that we should write the contractor and copy the owner after a site visit to notify them of something wrong?
No, you don't want to write anything down for safety.
Because that's okay. You do not want to write. Okay, SM, go ahead and ask your question. I'll ask you to unmute. And Mike, if you have to go, you just let us know. Okay. We have three people in line. Perfect.
3622, does that constitute as agency between the architect and the owner?
As far as that's the one where we talked about the authority to reject work. Yes, that would be an agency situation there because it specifically says I have the authority, and ultimately it's the owner's project. And so if I'm saying I'm rejecting, you're rejecting on behalf of the owner. And so here's an example that may happen, or even the inspection. Architects is looking at it, and the drywall has gone up, and they're not really sure whether the plumbing was done properly behind. So the architect maybe has some suspicions, they're not positive. They tell the contractor, you need to rip that drywall down and we need to check the pipes behind. So the architect has the authority to ask for that. Contractor rips the drywall down, and lo and behold, the pipes are done properly. Contractor puts the drywall back up and has to pay their drywaller to do all that work. The contractor can submit a change order to the owner, even though the owner didn't have any idea that it was going on, to pay for that work because the architect was there acting as the owner's agent and had that authority. Now, if the plumbing and pipes were improper, then the contractor would have to pay for that because the architect was correct in its inspection and wanting to do that. So the contractor to pay for all the drywall and the fixing of the plumbing. So that definitely is an agency situation under 3622.
But in general, well, certainly the architect has a role as an agent in that situation. In general, is the architect the agent of an owner?
No,
does the architect speak for the owner?
Only in the specific examples. That's what that
right. That's where I just wanted to make sure that came across because that's a big NCARB. That's a big ARE thing. Is that the architect is not an agent of the owner. Yeah. All right, Vesna is our last one.
I would like to better understand the fact that if you see something, you shouldn't write it, but in which case we should inform our owner, for some things that we saw and we think that it's not appropriate and it's not safe. That's my confusion, like not in writing, but how we can approach that.
So the answer to the question is two-part. The first part is the official answer, legal answer, and as your lawyer, I would say, if you see something unsafe, you don't say anything, because if you do, you have now brought yourself into being responsible for safety. And if an injury occurs relating to that condition, you have now implicated you and your firm, and you have an obligation there. And so officially, as your lawyer, you have to ignore it and say nothing. As a human being, what I would do is, like I said, is I would pull the project manager aside. I'm not even sure I would go back to the owner. Now, if you see repeated issues over and over about an unsafe site, you may want to have a conversation again with your owner and say, I don't trust this contractor. You need to bring in a safety person to take a look at this and hire somebody separate to overlook their shoulder. It's not going to be you, and you don't have to even give examples, but you would say to the owner, I've had some concerns about the general safety and welfare of this project site, so you need to do something, owner. But you have those as conversations. The reason why you don't want to put it in writing is because of this exact case that I was in. Once that one sentence document that we had in a set of notes was discovered, the architect was responsible and in for the project. Now, again, they weren't as responsible as the general contractor, but they had to stay in the case. And so that's why you don't write it down.
Mike, could that be addressed in the next round of the, because that is that always lights up the chat, this discussion, because architects we're golden retrievers. We just want to help out. Like we're not made to be told, we're not made to just sit there and watch someone get electrocuted. So is that something that could in theory be addressed in the next version of the contracts, where you would say something like, if the that everyone agrees that if the architect brings a safety concern to the contractor, here's what he or she should do, and by following this procedure, he has not taken control over means and methods or safety on the site in any future litigation. And everyone agrees to that, because it's in everyone's benefit to have, certainly in the owner's benefit, to have the architect just say, oh, there's a giant open pit.
Yeah, it'll never be put into the agreement that way, because anytime, whether it's an oral or otherwise, contractually, it's going to be a question of how much and how far, and should you have gone further? Did you go enough? Did you raise the thing? And so now you're responsible for safety issues. And then architects, their insurances won't cover it. So there's all these business reasons why you just can't legally put that in. You have to keep the architect as, I'm not responsible for safety. And I honestly, when I tell this story about the issues, like I said, if it's general safety issues, I wouldn't even say anything other than maybe the owner say you need to bring somebody in. If you see something really egregious, that's when you pull the project manager side. But I strongly recommend to the architects stay out of the world of safety, because it's going to cost you and your client, or you and your firm, a lot of money, and that then hurts your insurance rates going forward, and people won't hire you. And so there's all bad reasons of why, unfortunately, you don't want to talk about safety. So.
All right. Well, thank you so much once again, Michael, for helping us out, and we really appreciate it. Those of you guys who don't know, go to the Perkins Coie lectures, COIE, Perkins Coie lectures. Most of you guys know about those, but those who don't, they're also called the Hanahan lectures or the Schiff Harden lectures, because Michael used to work at another firm called Schiff Harden. And everyone, good night. Get licensed.
Thank you, guys.